So once again, good morning. Thank you for joining us. My name is Alex McGarris, partner in Venables New York office. I'm joined by my partner, Jonathan Pompan. Hopefully, most of you tuned in last week when we did part one of this series on the upcoming effective date of the CFPB regulations under the FDCPA. If not, that presentation is available on our website and you're free to access it. Today is part two. We will be covering the sections of the upcoming rule that we did not cover last time. We are offering CLE credit again, so please stand by. We'll be giving you the code needed in the middle of the presentation. Today, we're going to cover the following. So first, we'll do a recap really briefly on what we covered last week, which was focused on the provisions of the rule that cover communicating with both debtors and other third parties. Then we'll discuss the disclosure requirements under the rule, including the validation notice requirements. Then we'll discuss disputes and how the rule governs what is required when a consumer makes a dispute about a debt. The credit reporting prerequisite that is new under this rule. We'll discuss also the provisions that relate to transferring accounts if they've been paid, settled, or discharged in bankruptcy. The record retention aspect of the rule, and then finally, some key takeaways, a checklist for you to be able to use as you enter the last stretch before the rules go into effect. So last week, we covered the various sections of the rule that govern communications. Taking a step back, the rule applies to only debt collectors as that's defined in the FDCPA. The rule does not extend to first-party creditors that are collecting their own receivables, but to third-party debt collectors or debt buyers that are collecting the accounts that they've purchased. The rule does a lot of incorporating what the FDCPA says itself and updates it in a variety of ways with some specificity that was needed based on the kind of vagueness of the original statute. And one area is time and place restrictions. The rule says that, again, you cannot communicate with a debtor at a place or time that is inconvenient. The consumer can designate what is inconvenient for him or her, and that needs to be honored. And there also, the rule sets up some presumptions on time windows and whether or not you can contact folks at their place of employment. The rule notably has put some very specific boundaries on how often you can call someone in order to comply with the FTC provision regarding frequently engaging someone in intent to harass and abuse them. So that's, the rule says that you are presumed to have violated the statute if you call someone more than 7 times in a 7-day period, or if you contact someone more than once after engaging with them within a 7-day period. So the 777 rule. And then the rule also creates a brand new term, a limited content message. It's defined very specifically. The voicemail message has to include very specific pieces of information and cannot include almost anything else other than what's laid out in the rule. The benefit of this new term is that if a voice message left with a debtor meets the definition of a limited content message, it's not considered a communication, and therefore issues of disclosure to third parties is not in play. That said, limited content with messages still count towards the call frequency limits under the 777 rule as attempts to communicate, and so we need to be mindful of that. The rule also expressly addresses email and text message. The statute itself was passed in the 70s before those means of communication existed. The rule clarifies that you can communicate with consumers using text message and email, but of course, there is always the concern of third-party disclosure when you're dealing with email or text message. And so the rule lays out a framework that sets up a way to benefit from a safe harbor if you implement very specific procedures with respect to contacting people using email or text message. And so if you implement those procedures as laid out in the regulation, and you can benefit from a safe harbor in the inadvertent experience of disclosing by accident the existence of a debt to a third party. With communicating with these methods, you have to always give folks an ability to opt out of receiving communications through these channels. And so the capturing of opt-outs is a really big part of this rule and will be a big part of implementation to ensure compliance with the regulation. And then finally, the rule makes clear that while you can use social media to communicate with consumers, you cannot do so if the communication is viewable by the general public. And so posting messages on Facebook, for example, would not be appropriate, but there are ways to engage with consumers via social media, if you wish, under the new rule. And so that was the recap. A lot of nuance to some of those requirements. I'm happy to answer questions if we didn't get to them in last week's session. If you submit them through chat, we can get back to you by email. But turning to an area that we did not discuss last week, the disclosures requirements. The rule generally just restates the FDCPA's requirement that a debt collector must disclose in his first contact with a consumer and each subsequent one that the communication is from a debt collector. So that's the mini Miranda that we're all familiar with. With the creation of the limited content voice message that I just discussed on the previous slides, those don't need to include the mini Miranda because they're not considered communications. And so that's the benefit of this new term, is that you can leave voicemail messages without having to disclose that communications from a debt collector. The rule goes on to say that any required disclosures, meaning disclosures that are required under the FDCPA, must be made in the same language that the rest of the communication is conveyed in. So if you're sending a letter and you're including, it's going to be mostly in Spanish, for example, the disclosures that are required under law have to be in that same language. You can't have parts of the communication in a different language and then the required disclosure language in English. So that's a new thing that you need to be mindful of if you are using foreign languages to communicate with consumers. Similarly, with respect to required disclosures, meaning disclosures that are statutorily required, they must be sent in a manner that's reasonably expected to provide actual notice. And so, using the mail is tried and true. When we're talking about newer communication methods, you need to think about for required disclosures to make sure that they're reasonably expected to be giving notice to the consumers. For required written disclosures, for example, the validation notice, those need to be sent in a form that a consumer may keep and access later. And so also they need to meet e-signs requirements, which are very detailed. And so when you think about something like a validation notice, while there's no specific requirement how it's sent, text message is probably not going to be a way to get that done through e-signs requirements. So you need to think about that. And then finally, there is a safe harbor under the regulation that, if for some reason the disclosure is not received by the consumer, the safe harbor prevents liability so long as you mail a printed copy of the disclosure to the last known address. That's always an option if you're dealing with email addresses, for example, that you're not sure are being used by the consumer. You can always send something by mail as a safe harbor. And so the validation notice, which has been obviously around since the passing of the FDCPA, has been addressed more specifically in the regulation. It has to include very specific information now. The CFPB has provided a model notice, which is up on the screen right now. I think last week they issued a model validation notice in Spanish, available on the CFPB's website. And this is what they're expecting. It's a huge change for, I think, most companies in the space. And so this is something that if you have not, updated your notices by now, you just definitely get that going. So it could take a while to make the changes, but you'll see all the specific information is laid out here. So it needs to include the debt collector's name, mailing address where you accept disputes and requests for original account level documentation, the consumer's name and mailing address, the name of the creditor to whom the debt was owed, the account number associated with the debt, the name of the creditor to whom the debt is currently owed, to the extent that has changed, an itemization date and the amount of debt on that date, and then an itemization of the current amount reflecting interest, payment, fees, and credit since that date. So a lot more information than maybe your company has been providing. So you want to make sure that, given all the litigation that validation notices was generated, that you get the language just right, and consider using the model notice that the Bureau has published. And with that, I will turn it over to Jonathan to discuss disputes under the regulation, and we'll take it from there.
Thanks, Alex. And no shortage of requirements to keep in mind with the new rule. Now, the new rule also includes some requirements and some build out of the FDCPA's dispute category. And so disputes certainly are something that anyone in the collections area is familiar with and should note. But as we're discussing here on the next slide, a dispute really is sort of a key area for compliance, because ultimately organizations that receive disputes are subject to certain timeline reporting requirements internally and need to have certain processes and procedures in place. And then also it relates, of course, also to the rest of the collections engine with respect to communications to debtors, whether or not that would be done, attempts to collect, et cetera. So the rule restates the FDCPA's requirement that a debt collector must cease collection of a debt or any disputed portion of a debt when a debt collector receives a written dispute. Now, a debt collector may not resume collection of that debt until the debt collector responds to the consumer's dispute in writing or electronically. Now, if the consumer has submitted a dispute to the collector, it must provide a verification of the debt or of a judgment to the consumer. Now, a lot of that is already in the FDCPA and procedures that would be in place already at a third-party collector. But what's interesting here is that the rule also then goes on to say that if a debt collector determines that the consumer's dispute is duplicative of an earlier dispute as defined in the rule, and it essentially codifies the requirements there, a debt collector must either provide the consumer with that brief written statement of the reasons for the determination and refer to the consumer to the debt collector's response to the earlier dispute, or send a verification of the debt of a judgment to the consumer. Now, that doesn't really change anything, but it does codify with respect to interpretation in the regulation, the requirements around dispute. On the next slide, we'll talk about credit reporting. Now, credit reporting is one that's a little different here and is built out more significantly in the rule. So a debt collector must not furnish any information about a consumer's debt to a consumer reporting agency or CRA until the debt collector has completed one of the actions that we'll discuss now that is stated in the rule to notify the consumer about the debt. And there's a couple different options. Speak with the consumer in person about the debt, speak with the consumer by telephone about the debt, mail the consumer a letter about the debt and wait a reasonable period of time to receive that notice of undeliverability or therefore make the reporting, or send the consumer a message about the debt by electronic communication and wait a reasonable period of time to receive a notice of undeliverability. Now, the undeliverability notice doesn't mean that you have to have a confirmed receipt of communication, but you do need to wait a reasonable time. Now, that restriction on reporting information to a consumer reporting agency discussed here is about the information furnished about a debt to the CRA that compiles that information, so the typical CRA. And that includes, of course, the big three or any specialty CRAs. The debt collection rule prohibits the practice sometimes called passive collection, where one would place a debt in the collections queue, not necessarily communicate with the collector, but still report to a credit reporting agency. Now, those four methods that we just identified and that are identified in the rule allow an organization some flexibility. It could, of course, include oral or written or electronic communication. And in fact, you don't actually have to have a confirmed right party contact with respect to the consumer. You just need to make sure that it's not undeliverable. Now, the debt collector that's provided a consumer with a validation notice about a debt pursuant to the rule that we've just discussed has conveyed information to the consumer about the debt. So there is some interplay there with respect to how the credit reporting requirement here works, or really restriction on credit reporting, and then also the communication with respect to the validation process. Now, if you provide information about the debt orally, the collector can begin furnishing that information about the debt essentially immediately after speaking with the consumer. But if the debt collector uses any of the other methods, you have to wait and have a process to document that you had waited and are storing any undeliverability messages, taking that into account. So there's some build out there that would be necessary in order to do credit reporting if using any of the other methods, including electronic. Now, if you receive that notice of undeliverability during the reasonable period of time, you still can't furnish that information. So you have to have a period of time there that's built in and that you use as the cutoff. You don't have to necessarily, again, receive that notice immediately. And the rule provides for essentially the idea of a cushion of a reasonable period of time. Now, also the rule has a ban on certain debt transfers. The rule, for the most part, in part one and part two today, we've discussed procedural aspects of debt collection, items like communication, electronic delivery of notices, the ability and guidelines around electronic communication for collections of a debt and attempts to collect a debt. We've talked about validation and disputes. We've talked about credit reporting. All of those relate to interactions with the actual consumer, the debtor. In this instance, though, this aspect of the rule is essentially sort of disconnected from those. It's not a process-oriented aspect of the rule. Rather, it is a prohibition on the sale, transfer, or consideration or placement of the collection of a paid, settled, or discharged debt with respect to ownership. So generally, a debt collector must not sell, transfer, or otherwise assign for consideration, compensation, or otherwise, or place for collection a debt if the debt collector knows or should know that the debt has been paid, discharged in bankruptcy, or otherwise. And a debt collector doesn't transfer that debt for consideration when the debt is just sent for collection information, but rather if you have a situation where you would be collecting on the debt, there's a prohibition, though, on actually selling that debt. So a know or should have know, of course, is a legal standard. And if, for example, an account management system indicates that the debt has been paid or settled, that would be sufficient. There may be other information, though, that you might have as well that would satisfy that requirement. And depending upon the circumstances, you may have a situation where you have information and through other channels, or, for instance, if you're part of a service provider relationship, there's other parties involved with respect to the debt that may have that information. So sort of have to circle the wagons there before making any decisions. Now, depending on the circumstances, a debt collector might have a bona fide error defense regarding the transfer, sale, or discharge of a debt in bankruptcy if you utilized commercially reasonable databases, other information as well, to supplement the knowledge of the organization with respect to bankruptcy. So again, the know or should have known concept is important. There are some exceptions, though. Again, if the previous owner had received information or it's stipulated for a representation, for instance, from that previous owner in the contract, a transfer as a result of a merger or an acquisition or other transaction that took place where there's an overall assignment of substantially all or essentially all of the assets of the collector, including the accounts. Now, that does not just apply singularly to the accounts. That would have to be something more substantial, probably. Sales or transfers or placements of secured debt, discharged in bankruptcy if certain conditions in the rule are satisfied, and also securitization of the debt, pledging some portfolio with respect to, say, like a securitization trust where there's some collateral too. That would not necessarily, and certainly under the rule, the rule doesn't suggest that that itself would be considered a transfer for consideration that would be prohibited here under the rule. And it's important because certainly there's a number of debt buyers and investors in the securitizations world for which something like this could hamper that aspect of the market. But the CFPB and the authorship of this debt collection rule accounts for that, addresses that. Now, there are some legal requirements also around record retention. And record retention is one, again, it's much more of an internal housekeeping matter than it is one with respect to how one communicates or attempts to collect a debt. Now, generally, a debt collector must maintain records that show evidence of compliance or non-compliance with the FDCPA, Fair Debt Collection Practices Act, and other legal requirements with respect to its activities as a debt collector. Now, the debt collection rule starting on November 30th is going to require that activity to be retained in various formats for a 3-year period. And after the collection of or attempt to collect on a debt. So it's essentially a rolling period and it's on a per account basis. It's not on a systemic basis by any means. Now, that record, again, should stipulate to how one complies and also evidence the relationship of that information to an account or a system or otherwise. Now, the rule itself also goes through some various examples, and otherwise we'll unpack a little bit of it right now. But importantly, too, for those who are on for CLE, we've just hit sort of the halfway mark, and want to note the CLE requirement today, Collector 2021. And so that's the code for today's CLE. Anyone seeking CLE will also have the opportunity to use the information that we send after this session with notation with respect to attendance today, as well as also the materials for relevant jurisdictions. So back to record retention. So record retention requirement is new in the rule. Nothing in the rule prohibits a collector from retaining records that are evidence of compliance or non-compliance longer than 3 years, but the key is 3 years, and that starts at the end of November. Now, the scope of records that need to be retained is enumerated in the collection rule, and the nuances is that which would reflect compliance and that which would reflect non-compliance with the rule or the FDCPA. If a record is a type that could evidence compliance or non-compliance, and that information about the collector is revealed in the record, then that's one of evidence of compliance or non-compliance that has to be retained. That's a mouthful, but ultimately there's a lot of records that would be covered by the rule. Those rules, or rather records, include evidence that the collector has communicated or attempted to communicate. So that would be call recording records. That would be the dialing records. That would be the records used to select what time of day and place for collections or attempt to collect. It would include the retention of the telephone log. And then, of course, for anyone using electronic communication that's not telephone, but for instance, email or text messages, consider those requirements grafted on to that. So that would be your text message log, the information about whether or not anybody submitted a stop request or the opt-out request that we discussed in part 1 of this series. Also, you would have electronic communication records. Now, those records are not going to necessarily be always identical within all organizations for all types of communication, and they are not necessarily going to be identical across all collectors. In other words, collector A may have a different type of set of records that are subject to retention as compared to collector B. But importantly, there's going to be certain minimal things that, for instance, the Consumer Financial Protection Bureau in an examination or investigation situation would be looking for. So at a minimum, one would expect that you'd have some systems in place in order to substantiate the compliance with the law, essentially a get out of jail free, something that would be good. And certainly for purposes of taking advantage of any bona fide error defense, the lack of records would make that essentially a no-go. So having the records is a necessity. Certainly there's some discussion also, I know, within organizations, should the retention period be longer? That may vary. There may be other reasons why certain records should be retained, or some of these records should be retained for some period of time, longer than the 3-year period. In addition, I think what would be extremely relevant too is to consider a top-down and a bottom-up analysis of retention in terms of what needs to be retained and what doesn't. As certainly many organizations for years will have any number of records generated in the normal course of business. But consider here whether or not there are specific records that should be essentially generated in order to help satisfy and substantiate compliance with the rule and the FDCPA. Now, there are some circumstances too where that 3-year period becomes longer than the 3 years that would automatically be in place, simply because there could be, for instance, a situation where there could be a debt transfer, some other situation where retaining certain records would actually be advantageous for longer than 3 years. I think an important thing, though, we get this question a lot early on, and when the rule was announced last year, do the records have to be retained in paper form? And that answer is no. You can retain it in any method that reproduces the records accurately, including computer programs that ensure that the debt collector and can ensure essentially that you can easily access those records, including the contractual right to access records if they're records that are generated by a third party service provider that you may be engaged with to provide some certain functionality around any number of systems and other processes you might have in place, or even some subset of the collections process itself. The ability to access those records is amplified, certainly in a CFPB examination situation where you might have a 30 or 45-day collection period prior to when materials and information have to be produced to the CFPB. That window sometimes can be shorter, sometimes it may be longer. So it's not hard and fast, but certainly the lack of an ability to access those records would hamper cooperation and satisfying the expectations with respect to any exam. Similarly, in an investigation scenario, while these records may or may not be part of some larger request, the ability to access the records promptly can make a huge difference in both the burdens on the organization, as well as also the ability to substantiate compliance. Of course, good records would naturally show compliance for organizations that are following the Debt Collection Rule and Fair Debt Collection Practices Act. And also, in addition to showing compliance, they would also reflect the policies and procedures being implemented. So there's a lot of opportunity to use the records that need to be retained to tell a positive compliance story in addition to the bare minimum. Or any organization considering that, of course, should weigh the relative benefit to the burden of generating that type of paper or record and information, and also think about that holistically in addition to individually for various systems that may be in place. Now, this is the moment where we're going to turn to some key takeaways, and Alex and I will discuss a variety of different takeaways, some of which are systemic, some of which are also very specific to certain aspects of the debt collection rule. First takeaway, very important, the rule takes effect at the end of November. It doesn't take effect next year, 60 days from November 30th, or even 6 months from November 30th. November 30 is the day. So organizations should have in place the various bells and whistles that they need to comply with the rule at that time. Certainly, we will start to see the examination process for collectors and any investigations start to incorporate these concepts to the extent that they haven't already. And we expect to see the modules updated, as well as also the analytical aspects of an exam updated as well for things ranging from the 777 rule to obviously record retention. And so as a sort of number one takeaway from a big picture standpoint, November 30. That may mean that there's certain aspects of operations that would have to possibly be suspended if those steps aren't in place. Although bear in mind, much of this rule is permissive, at least on the communication front. So not all of the communication bells and whistles around, like for instance, electronic communication necessarily have to be implemented. Those are safe harbors. You can choose or not choose to take advantage of them. But there are plenty of aspects of the rule that are requirements that are triggered by certain activity, and record retention is a great example. That is one that it bears on the entire organization. It does not. It's not permissive, and it's not necessarily generated by any activity that is permissive, other than this collections activity as a whole. So. Also, call frequency. Now, Alex, call frequency is one where we've probably gotten some of the most questions on over the last year. Any tips on call frequency?
One of the questions we actually just received on the chat that relates to call frequency was, if you speak to a consumer and there is a promise to pay the next day and that payment does not come in, do you have to wait 7 days in order to re-engage with that consumer? And the answer is yes. If you have made contact, you do have to wait 7 days unless you either have that consumer's consent to contact them, or, well, there's very few other exceptions that would apply in that scenario. So what I would say is, for purposes of wanting to have organic conversations with consumers, is training your folks to obtain that consent to contact the consumer if something doesn't happen. For example, the payment doesn't come in. And so when I think about the call frequency limits, I think of it in two ways. So first is the technology that allows phone numbers to get dialed. I think at this point in time, everyone's using pretty sophisticated dialing technology to do that, and not having folks, your collection staff, literally enter phone numbers on a phone. So making sure that your dialing technology is properly coded so that the 777 rule is hard coded into those practices is very important. I think we all understand that these types of changes to technology take a long time, and your IT folks are always being asked to do many things at the same time. So that to me is something that had to be already in motion in order to meet the deadline. I think at the next few weeks, it's really about making sure that it's working, testing it, catching exceptions, and exception reporting to go live on the 30th. The second part of the call frequency limits in terms of compliance is capturing consent and training your folks to ask for that consent to talk to somebody more frequently. And that's permitted, and that's natural when you have, people living their lives, things get forgotten, etc. So in the example that I just gave, where there's a communication, the consumer says, I will, make payment online tomorrow. You can ask that person, well, is it okay if I contact you on Tuesday or the day after, if for some reason that payment doesn't come through? And if the person says, okay, then you have that direct prior consent. It needs to be captured in a way that you can demonstrate that you had it. Just your debt collection staff are writing a note on a piece of paper is not going to do it. So again, it's all about training people to keep the systems, the record updated to capture all of these consents and preferences. Same thing with, other kind of communication issues that are inevitably going to arise. We talked a lot about opt-outs, and that the consumer can be as specific as, you can call me at home on Tuesdays, you can call me at work on Wednesdays, but not at these times, and only email me on the weekends. I mean, it can get that absurd, and that all needs to be captured. So preferences about when and what channel to communicate with consumers needs to be, if to the extent you're going to be using multiple channels to communicate with consumers, which is probably a good thing. I think everyone sees the benefit of getting the consumers buy-in as to when to call that person and at what number, but that all needs to be captured in the system of record. and in a way that you can abide by those preferences, right? So whether it's hard coding it in a dialing technology or requiring your employees to check all preferences and not violate the consumer's preferences. You know, there's not one way to do this, but it's going to require a lot of training. And so I think the dialing technology changes and training of your staff to capture preferences and opt-outs and opt-ins and consent to contact someone either more often than what's allowed, or you know, if someone designates something as an inconvenient place to be contacted, but they're going to only be available at that place for the next 3 weeks, and they say it's okay to contact them only for the next 3 weeks at that place, then you want to be able to capture that. So all of that is going to, I think, be the key emphasis the next few weeks for organizations.
And on opt-out notice, one of the things that I think organizations really should bear in mind is that opt-out notice is required for any and all electronic communications. So as a result, any organization that may be transitioning to various electronic communication technologies, as well as also campaigns and utilization of different internal systems than perhaps previously had been used. As a result now of trying to take advantage of the safe harbor, as well as also the rule and sort of the general interest now in electronic communications. Those organizations need to bear in mind that the system for the opt-out needs to be in place sort of as a gating issue to any use of those electronic communications. Now, that may be obvious because of the requirement, but it's not one of those things where the opt-out engine can come second after the electronic email engine is in place. It needs to be used for all of those communications. So certainly we know a lot of organizations have been upgrading and advancing their policies, procedures, and intentions come the new rule. But the opt-out piece in particular is one where that will be something very easy for a consumer or a examiner to see in the review process. And as Alex mentioned too, the systems of record need to be updated to reflect that information. And in addition, I think as a matter of compliance and convenience for any monitoring or auditing taking place, those records need to be easily tied together with other aspects of the system. And I certainly can see that could be an area that could be a disconnect. Oftentimes there's different vendors being used for different pieces of this, and at least coming up with a holistic way to capture all this information. And again, also for the record retention requirement would be important. Also, one other takeaway here too, and this is the one really a big one for any first-party creditors on the webinar and watching this information. Now, as we've talked about and is well known, the rule is not directly written to apply to first-party creditors. The typical lender in a origination and servicing context, but anyone with a collection strategy utilizing a collector is going to have to transfer certain information to the collector now that they may not already be doing for validation notice purposes. Now, it may be in some cases minute differences than what was previously provided. Certainly many collectors for various reasons would receive the information that would be required now to be included in that validation notice. But there's some very specific requirements. And at times too, certain information may have only been transferred either on demand or later in the process, even after an account had been placed. Now, a lot of that information, or essentially all the information, obviously for the validation rule, has to be shared with the collector up front so they can be in compliance. Now, most collectors, of course, have been working with their customers, original creditors, to sync up on that. But that is something that we know many are working furiously on, to the ramp up stage to November 30th. And from our perspective, if one were to ask, what's the number one thing a original creditor needs to know, just even as a technical ops matter, it's those validation items and what needs to be included there and those changes that need to be made. Now, obviously on the collector side, with the new validation form and the various data that needs to be implemented, there's been no shortage of work on that side as well. As Alex mentioned, the Spanish form was released last week and is available on the CFPB website. It's certainly been circulated by the trade associations as well, I believe, information about that. But there's going to be no shortage of need to evolve on that front as well as time goes on.
Yeah, just a few more minutes on the validation notice. So the regulation provides a safe harbor if you use the model notice that the CFPB has published. And so first and foremost, I'm not sure if I made that clear. So if you do use that notice or someone that's substantially similar, then the presumption is of compliance. A couple of things about that. So first, and we have a question about this, about adding certain state required disclosures on the back, the reverse side of the form. The regulation makes clear that is permissible so long as the front page notifies consumers that there are important disclosures on the reverse. So you still can take advantage of the safe harbor if you put some disclosures on the back, but you have to notify on the front if that's the case. Disclosures about out-of-stat debt, however, need to be on the front if you're providing those. The rule is relatively silent on out-of-statute debt. It just prohibits bringing lawsuits or threatening to bring a lawsuit on out-of-statute debt, which I think everybody has understood that to be the law as courts have interpreted the FDCPA for quite a while now. So nothing monumental on out-of-stat debt in this rule. The form also is, as you know, requires you to tell consumers about some rights that they have under the FDCPA, including the ability to dispute the debt or a portion of the debt, or to request, information about the creditor or documentation. You can accept disputes or requests for information electronically. That's a question we received. The regulation allows that to be the case. You just need to, in the validation notice, tell consumers exactly how they can file such dispute or make the request electronically. So if we provide the email address or provide a link, et cetera, if you want to force consumers to use electronic methods for taking advantage of those rights. And so another question we received is about whether first-party creditors should use the validation notice and the one that has been published as a model notice. As Jonathan mentioned, the rule does not apply to first-party creditors. I think a lot of the requirements around communications maybe make sense for first-party creditors to implement, to the extent they're looking for some concrete, answer about how often and to contact someone, et cetera. On the validation notice, I think kind of a square peg round hole, given the point of the validation notice. And so, as Jonathan mentioned, really for first-party creditors, when it comes to the validation notice, is when you're placing debt with a third-party debt collector, which will be subject to the regulation, or selling that debt, you need to make that information that needs to be in the validation notice that those third parties send. You need to make that available to them in order for them to comply. And so you're going to obviously see that from your vendors when the rule goes into effect. They're going to need that information from you. And finally, on the validation notice, the benefits of adopting, I think the model notice and the safe harbor seem to be advisable, especially if you're dealing with a lot of things that you haven't been doing before. I think some companies in this space have already been providing a lot of the information that's required because of consent orders that have been entered into years ago. But for other companies, that this is going to be a radical departure from the way validation notices used to look like. I highly recommend taking advantage of the safe harbor and adopting the model notices. And then finally, on the credit reporting, I think there is another kind of, your IT department needs to do this thing, putting another thing on their plate. Presumably you already have, but if credit reporting was happening kind of automatically based on a date that's unconnected to contact with a consumer. So for example, if you credit reported, X number of days after placement or X number of days after loading an account into your system, that will not be compliant. You now have to wait before you can report anything to the credit bureaus until you've made contact or sent a letter and waited a reasonable amount of time. And so that's a relatively simple change, but it's a big change to the extent that your credit reporting is triggered by something else. And so that needs to really be on its way to meet the November 30th deadline, because that would require a big IT change, I think, for most organizations. Jonathan, anything else you want to add on any of these checklists?
Well, I think one of the key things to bear in mind for every organization is that the checklists are different. And while we're providing some takeaways here, there are other takeaways that you may have based on your own internal operations and practices, as well as also your customer base or your vendor relationship, depending on which direction we're speaking in terms of creditors and collectors and debt buyers. But the key is that there's something in here for everyone, meaning in the rule, there's some aspect of the rule that touches every corner of the collections and receivables management process. Again, regardless of whether or not you actually are directly going to be held to compliance with the rule or could take advantage of some of the rules safe harbors if you're a third-party debt collector as defined under the FDCPA. Importantly, the rule itself also provides no new changes with respect to the definition of collector. But as Alex mentioned, for those looking for a baseline, arguably that may be a baseline for what would be constitute an unfair, deceptive, or abusive act or practice under the Consumer Financial Protection Act, especially for first-party creditors and lenders. There is no shortage of suggestions in this rule as to what those might be. Now, remember, for those that participated in part one or any of our earlier webinars and sessions on the debt collection rule, going back now almost 10 years, the reality is that the Bureau has always been thinking about whether or not to do first-party rules for collections or servicing of accounts. Some of that comes through in other ways, through other statutory authorities and other expectation setting. But as a key thing here, bear in mind, what's next. And at a minimum, there's going to be the upgrade and enhancement to the CFPB's examinations of collectors for compliance with the rule. And to some extent, again, as has been emphasized today, there's various pieces that connect to first-party creditors. So if first-party creditors are not providing information that is required to collectors, if they're engaging and retaining the services of collectors that are out of compliance, it is entirely possible that the first-party creditor could be held liable by the CFPB under substantial assistance or authority, which can hold the principal responsible for the hiring of a vendor, as well, who should or does know that they're out of compliance with consumer financial law. And then there's also the potential for other liability as well that would attach to that first party creditor. So in any event, everybody needs to be paying attention to this and cross-checking. Now, big picture takeaways, just to recap, the CFPB clarified that the consumer has the ability to dictate when, where, how communication is going to be done. That may be electronic, it might be written, it could even be in person. But for each one of those now, there's certain parameters. And of course, for electronic communication, the opt-out requirement to facilitate that. The CFPB created a rebuttable presumption that a debt collector complies with the FDCPA if they follow the 777 rule for communications by phone. That's a new one. CFPB provided clarity regarding the application of modern communication, the electronic email, text messaging, use of social media, how advertising would fit into all of that, which ostensibly it wouldn't if it's not actually direct communication about attempting to collect a debt with consumer. The debt collection rule also has a variety of disclosure requirements around validation and dispute. And then, of course, we also highlighted record retention today. That's not all of what's in the debt collection rule, though. We cannot emphasize enough that the debt collection rule contains a lot of other aspects and requirements that may be relevant to your organization, as well as also requirements and nuances about how all this gets implemented. So by no means, of course, was this exhaustive, but we hope this summary today and in part one was helpful, particularly as we approach the November 30 deadline. Now, of course, each organization might have a different compliance position, requirements and responsibilities, but we hope at a minimum this is enough as a baseline to get you started or as a final refresh. With that, today's session is going to be coming to a close. We certainly welcome any questions offline. And also, please, if you have any feedback for us, please, we welcome that. And then please subscribe, hit notification if you're watching this on YouTube. And we thank you for today's attendance. We had terrific numbers, and we know folks are interested in it. We're going to do more of these. We're also doing a session in early November on consumer financial protection, investigations, and enforcement. And please check out our website at venable.com/CFS/publications for more articles and presentations on this and related topics. For those seeking CLE today, our session is going to be using the code Collector 2021. Thank you for attending.